Our firm, Wagner Sidlowski, is a boutique litigation law firm in downtown Toronto. We are presenting this video/podcast on the formalities of execution in Ontario. Let's join Charles and Liliana as they discuss submissions to be made on this issue to the Ontario Court of Appeal. Liliana, it's time for the podcast. Are you ready?
Yes, Charles.
I have an appeal pending. You've done some work for me on the legal research. So I would really appreciate your help in preparing for the actual submissions to the Court of Appeal.
Okay.
Let me lay out the facts for you, the case, just to give us a running start. Testator is in the hospital, paraplegic, has no movement whatsoever, can only speak. Calls lawyer into the hospital. Explains to lawyer that he only has one distant relative, a cousin, and he wants to leave the entirety of his estate to his best friend. The lawyer rushes back to the office because the client's an extremist. He rushes back to the office, drafts the will, brings back his secretary, reads over the will to the client. The client says, yes, that's what I want to do. And before the will is signed, or before the testator can give instructions for someone to sign the will on his behalf, the testator dies. There's no previous will. Our client is the distant cousin. He takes a position that, given that there is no will, because the formalities of execution have not been complied with, the document was not signed, there's an intestacy. And given that our client's the only relative, he inherits everything. The best friend takes the position that there's been substantial compliance with the formalities of execution, that the will is valid. At trial, we win. The judge decides that because the will was not signed, it's not a valid will. The matter has now been appealed. What I'd like you to do is I'd like you to role play. Imagine that you're one of the judges in the Court of Appeal. What issues do you think are going to be of concern to the judges?
I think the very first issue you're going to have to address is why the need for formalities of execution in this instance. There are certain cases or certain circumstances where we don't need to comply with the formalities of execution, such as a holograph will, which is the will wholly in the testator's writing and signed by the testator, gifts morta causa, or where a will is prepared by someone in the armed forces or a naval officer or someone of the like, again, signed by the testator in that instance. So if we're allowing for certain circumstances where witnesses don't need to be present and don't need to sign, why should we continue with a strict adherence to the formalities of execution in other circumstances?
Okay, I think that's something that the court might raise, and I know the other side raised it in their factum. So let me tell you what my response is. First, I want to address the role of the court and the legislature. The court's role is to interpret the legislation. There's no allegation that there's a constitutional question where the legislation doesn't comply with the charter. If the court's role is to interpret the legislation and the legislation calls for full compliance in these instances, then there has to be full compliance. My second submission is those aberrations that you talked about, a holograph will, the issue of a person in our military forces. Those are times of possible urgency, exceptions, and we don't take an exception and use it as a rule of general application. It's sort of like the Ettori case. Have you heard of the Ettori case?
Yes, that was a decision by Justice Cullity.
Right. Do you remember what Justice Cullity said?
I do. Justice Cullity essentially said it's not the court's at that level position to change the law. It's up to the legislation or Court of Appeal to consider whether substantial compliance is something that we should be looking at as a province.
That's exactly the point. What else do you think the Court of Appeal might say?
I think a related point that the Court of Appeal might raise is the policy reason for still requiring strict compliance with the formalities of execution. There are other provinces in Canada that no longer require strict compliance. For example, Manitoba, Saskatchewan, Prince Edward Island, Nova Scotia, New Brunswick, all have legislation in place that says substantial compliance is permitted. Also, British Columbia is now considering enacting legislation to the same effect. So if those provinces are relaxing a little bit and not requiring strict compliance, what's the policy reason behind Ontario's decision not to follow suit and to still require strict compliance with formalities of execution? What good are we trying to do by doing that?
Okay, I think that's a very valid point. And I'm working on my response. This is what I think I'd like to say to the Court of Appeal. There are a number of good policy reasons for Ontario maintaining strict compliance, full compliance with the formalities of execution. First, one of the problems we're trying to remedy is fraud. When we have full compliance with the formalities of execution, there's less of a chance of fraud. The second issue is certainty. If there is substantial compliance permitted in Ontario, you're opening the floodgates and you have the potential of so many more cases coming before the courts. And that's not what anybody wants. My name is Charles Wagner, and this is my associate Liliana Ferrara. We don't want anyone who viewed this podcast or video to consider it legal advice. It's not our intention. What we wanted to accomplish was to provide the viewer or the listener with a glimpse about how lawyers go about addressing complex issues like compliance with the formalities of execution in Ontario and the validity of wills. I'm a certified specialist with the Law Society of Upper Canada in Estates and Trusts and a partner in this firm. And often, young lawyers with cases like this contact me and ask my advice on how to proceed. Sometimes it's lawyers from outside the jurisdiction who have clients they represent who have a concern, something similar to this. It would be a mistake for anyone like that to view this as proper legal advice. But just like I'm happy to help them, I would be happy to help anyone else who has questions regarding this sort of thing. My name is Charles Wagner, and I thank you for listening.